just said it, but I think not everybody was there. The session will be recorded, or the workshop will be recorded for your information. And if you don't want to be on the recording, then you have to leave your camera switched off. Okay, then we will start. I like to welcome everybody from my side and also on behalf of Christian, who unfortunately cannot join today. Yeah, very welcome to the FORMOBILE online workshop, which will deal with ethical principles and eEvidence governance recommendations from the ethics advisors. This workshop is based on deliverable D14, which is the second ethics advisory board report. And the authors of the report want to share their results and recommendation for the FORMOBILE projects with the consortium. In this context, I really like to thank Uwe Ewald and Bernhard Witt for their very active support during the whole FORMOBILE project. Next slide, so we can look at the agenda of today. First of all, Bernhard will tell you about a little bit more about the role of ethics in FORMOBILE. Then I think both authors want to share their ethical values and principles which are relevant for FORMOBILE, and they formulated some ethical guidelines for the project. And they want to share, and then we go a little bit more into a practical work. Point 5, checklist for mobile forensic practitioners to enhance the governance of the forensic process and guarantee reliable evidence. After the presentations of the content, we want to discuss, or Denitsa will moderate the discussion of the content of the ethical guidelines, and what about the recommendations of Uwe and Bernhard. And Denitsa has also a big part in it. Thank you very much, and I like to give the floor to Bernhard.
Yes, thank you very much. So please go to the next slide. Just a quick introduction onto the role of ethics in FORMOBILE. We of the EAB differ two different goals. An inward-facing goal, which is strictly related to research and development, and therefore internal oriented, I would say. And the other thing is the outward facing goal, which is related to planned usage of results, and therefore much more outside oriented. So next slide, please. The needed extension we defined in our second report on ethical values is mainly motivated by the use of real data and its impacts. Therefore, it's on our point of opinion, it has to be regarded what may be going wrong. Uwe will describe later on that in detail afterwards. I think we will discuss several parts of it afterwards, and I'm delighted and enjoy this discussion with you very much. We are convinced of needing red lines from the beginning of our task as EAB. So next slide, please. You may know of the regulation of the Horizon 2020 program itself. So it said you have to comply to ethical principles and so on. And we think it's necessary to meet ethical standards. And we will look forward what you understand or want to know about our defined principles. Next slide, please. But there is an inherent ethical problem we find out. It's because of following reason. Information from real world may not be totally the same when it has to be transferred on IT systems. It's a question about modeling and designing of something that's always happen. And second, an individual image of personality or something like that on behavior patterns in particular may be different in the resulting views of what you say about the view on IT systems and on analyzing of data. This is a common problem for both perspectives, the inward perspective and the outward perspective as well. You cannot solve this problem, but you should be aware of it. And that's the reason why we mentioned it. So it's up to you now, Uwe. Say something substantial about the outward perspective. The stage is yours.
Thank you very much and welcome everybody. I can directly connect to what Bernhard just said, that we have to be aware, and this is why we try to explain and also, as you will see, operationalize the ethical perspective we developed for mobile, that there is some inherent dialectics, I would call it, contradiction or tension between resembling the reality in a virtual world through IT systems and how this comes down in our case. So what you see here on this slide is actually a word cloud which represents the analytical result of a few hundred of articles, books and other materials which have been available in a digital format. And we did a content analysis. So this is nothing we made up, but behind that there is all this material, which is in great part reflecting the discussion within the European Union and internationally on ethic values in digitization and big data analysis. So as you can see, and this is just as an introduction here to warm you up for what comes later, which will be much more structured and systematic, that security is in the center in its double or manifold meanings. Human rights, data protection, responsibility, but also governance. To tell you the truth, although I'm a little bit around in this area, I have not been aware that governance became such a strong issue in the discussion about ethical values and how to maintain and implement them in digitization, including the security sector, of course. But here we are still at the level, at the general level of digitization. Next slide, please. What we want to focus here is actually, and all of you who may follow up with this a little bit will know that at the EU level, I mean, Ursula von der Leyen is kind of emphasizing this issue quite a bit in her statements, that the EU, also in contrast to the United States or China or Russia, as other paradigms of how to deal with digitization in society, follows a human-centered approach, which I find has to be kept in mind if we go further, because this is not only a show window statement, because we now have to think about how to translate that. And that's actually what we tried in that report, to give some reflection and guidance, mainly since the inward facing perspective has been covered in the first half of the project, mainly referring to the outward facing perspective. And what we have here with the human-centered approach is that we have to see two kind of competing sides. At the one hand, we want to use digitization, big data to enhance security and bringing offenders to justice. And on the other, we want to keep a free society, an open society, democratic rule of law, and all what comes with it. Next slide, please. We try to symbolize this here, that we keep in mind this kind of balance. We finally have to strike also in FORMOBILE, at least this is our view, that, and from the outset, I would like to stress that in our view, this is not a zero-sum game or a mere contradiction, but it is a unity, a dialectical unity. I know this term dialectics is not too much used in our language, but it means that there are two sides which go together. So they kind of even compete, but you have to keep them together if you want to have it all and not lose one of the sides. I mean, we know the statement, security and justice. If you all put them on security, you finally, or freedom, you will lose the freedom. So here we have that security, unimpeded investigation and prosecution. This is one perspective, I would say, a little bit simplified, very much represented by IT forensic experts and law enforcement agencies, naturally, because that's one of their main parts, if not the main part. And the other side of that dialectical relationship is keeping freedom, effective safeguards for human rights and rule of law. Next slide, please. Remember, please, this word cloud. Now, of course, we went into details in this analysis, and we found within this discussion, we coded this and then clustered these items which were mentioned, and then could find two big categories. And remember always this duality we try to present here in our recommendations, or in our opinion we presented in this report. Here's again this duality. We have general guiding ethical principles, so to speak, the do's, what should we do? And there we found these 4 blocks: democracy and governance, professional standards, which in simple language refers to the professionalism of IT forensics mainly, then rule of law, this is the procedural aspect, and criminal justice system, but also sustainability. All this discussion when it comes to what are we actually doing with our work within digitization in different fields, it also and always raised at a general level the question, what will it, what impact, what long-term impact do we cause? And this is meant with sustainability, often referring to environment. Not sure how far digital evidence has to do with environment, but we definitely have some substantial impact on the democratic political structure of our societies as we know them. And I like to mention that regard Hariri, the Israeli philosopher, who said we really have to understand that we are at the brink or at the crossroad to decide either to radically, that's his wording, radically change our democracy society, or end up sooner or later in some kind of digital authoritarianism. So I don't want to dramatize, but just to make it clear what our perspective is when we emphasize the ethical principles. The other part, which we consider to be equally important as the investigative, or let's say prosecutorial part, if I bring it down to the criminal procedural sides, is actually the don'ts, the concerns, what we should not do or prevent of not happening. This is abuse, this is clear risk awareness, opacity, big issue, professional failure, and tension of ethical principles. I come back to this. So these four, maybe they are more or less self-explaining. Tension of ethical principles means, for instance, what I try to express with this picture or in the framework of this dialectical relationship, that we have the need to strengthen our security on the one hand, and on the other hand, we have a framework which sometimes might function as a limitation. So if this tension of ethical principle would occur, we need to mitigate it, like in the investigation of terrorist crime. Of course, there might be other means necessary, but what is needed here is also, again, based on the rule of law, like a legislative decision first, and not just to give this into the hands of the, let's say, police or uncontrolled by the judiciary. So next slide, please. Don't worry, we are not going through this in detail, but here you see how this, and again, this comes from the analysis of all those documents, and of course also involving many documents from the Council of Europe, which deals with digitization and security and rule of law and criminal justice systems quite a bit, how this is operationalized. So we could go into this, but the table here, this is for complex A. You see here table 6, that's from the report. There you can read it all in detail again. So I'm just trying to highlight here and trying to make clear the baseline of our thinking that as the guiding principles, and you see it's in a short term as a best practice, how the different ethical clusters, democracy, governance, rule of law, professional standards, sustainability, you remember these four big groups, have been cross-tabulated with ethical principles regarding truth-finding, fundamental rights, which refers to the right of the defendant mainly, but also the victim or bystanders sometimes, and ethical principles regarding the rule of law. This is the procedural aspect, how criminal justice is organized. So what we try to show here is actually that it is actually more or less possible in a straightforward way to operationalize these general ethical principles with the basic levels of criminal investigation and prosecution. Next slide, please. Yeah, here is the B category, the worst practices, so to speak, which we should avoid. And I will go into this issue a little bit later in more detail. And it's actually the same kind of pattern. You see the clusters, the ethical clusters, and the ethical principles, which refer to our criminal prosecutorial process. And we thought, so anybody who wants in the work packages or wherever, I mean, we finally will share this certainly with the public, would try to look into his or her own work as an expert within that chain of evidence, could use this approach to specify certain issues, to become aware about certain issues, and then to find an answer in the concrete field of work he or she is active. Next slide, please. As I already mentioned, we throughout this process of communicating and working on the report, we became aware that this issue of governance might also be highly relevant for the FORMOBILE project, and well, I explained how we became aware of this governance issue because it was so much strengthened and emphasized throughout the discussion that you simply couldn't avoid to recognize it. You couldn't ignore it. And then we had a deeper look and we found, yes, it should be true also for us in the FORMOBILE project within the wider community of law enforcement and criminal justice. So, and in fact, the ethical principles, so we have these two sides again, that ethical standards need to be applied throughout the cycle of the digital evidence. And there has to be a communication between the digital and analog language partners. This might be worth to go deeper into a discussion what this means, but in short, we believe that in the old analog or merely analog time, due to the fact that everybody can read and listen as the main analog information we perceive or perceived in the old style criminal justice process, it was easier also to understand how work was going on and to communicate things. This seems to be changing somewhat in the digital age because you need to lift up your set of knowledge, your skills, to handle digital evidence, since it is not directly empirically visible. And this again needs a different awareness of those who guide that process. In our case, would be prosecution, partly judges, depending on the system, but mainly prosecution. Next slide, please. And we tried, yeah, you can see it as an attempt to structure that eEvidence process, or the chronology in which eEvidence is processed from acquiring and actually going back. Phase one is the pre-acquisition, because it also has a meaning what actually was and is and happened to the digital evidence before it became potential evidence. But then going on from the seizure or acquisition, preparation, analysis, reporting, judicial evaluation, sharing, archiving, and data detention. So we mainly look here within that presentation till the reporting and finally sharing and presentation at court. But what is important here is that e-governance as the 10th level is kind of in the middle as a central issue, not just somehow attached, but central to make all these other parts work. Next slide, please. So, and by the way, you will recognize we call it E2GRM. That's kind of an attempt to refer to the grandfather of that type of model, the EDRM, the Electronic Discovery Reference Model, and we try to adapt that here just to help our own thinking to be structured. And here it is about how to interconnect this E2GRM with ethical principles. And well, as you can see, we just put it in a different format. And maybe we see it on the next slide, how this can work in detail. So, well, this was not, it's later coming. So no, just stay with the slide. It's okay. It was just to repeat the categories of ethical principles valid for mobile, or in general, we believe actually for the production of digital evidence, that we have that set of ethical principles and values related to the investigative analytical process, to the protection of fundamental rights and strengthening the rule of law. So these different levels, and now we can go to the next slide, are valid actually for all groups of professions, of experts, more or less, of course, sometimes less to the degree of zero, but everybody has to be aware within that process of digital evidence production that these guiding principles exist and should be accepted. So here is just a list of professional groups, which all for themselves actually, if they wish to operationalize and take some guidance from that model, could go into these values and have a look into their own work and trying to apply it. Next slide, please. Here now, would be the next step of operationalization of that model. You have the 10 or 9+1, the governance levels of the model. You have the tasks, you have the professional groups, and you have the ethical principles. So that's actually the closest we could get here, but thanks God. Next slide, please. We had already, without having our model, and this shows also to you that we are neither the first, and we are not claiming that, nor anything really new. We simply tried, nor did we do anything really new, but we simply tried to systematize this structure in light of the ongoing ethical discussion and in a holistic way. But in work package 1, there was, and this is underlying as far as I understand, also the work package 3, the CWA, has been developed some very similar kind of model, which is completely compatible with what we suggest here. So this was really a nice thing to see that actually we are running into, partly at least, open doors within the project. The question is whether whether there could be a common discussion and whether we can further develop that. And actually in the last part, we want to present an idea how we could proceed. Next slide, please. Right. Now it comes to actually, we also had a look to apply this model to the work packages, because we thought, so if we now have kind of an understanding about how the ethical principles in the outward facing perspective could work, let's have a look what we have so far and come up with some opinion and also some ideas how to well, maybe trigger some new thoughts or rethinking. And that's what we tried. In the course of preparation of this presentation, we then decided, in light of the set time frame, not to go through each work package. You can read this all in the report. So in fact, I think this is actually a good solution that we don't now touch on that. I will still refer to it in a more general sense. But if there's any wish, need, whatever criticism on our views, of course, we are more than open to have a communication and discussion on that. And please, in that regard, have a look into the more detailed reflections in the report. Just in brief, I would like to say that, in my view, Bernhard, correct me or add something if you see this differently. In my view, our main kind of contrast in a productive way, and again, this is not to blame anybody for us ourselves. It was a new procedure, and we came out a little bit more enlightened than before we studied all this. But in contrast to what has been going on so far in the project, we could emphasize that what we would like to reconsider in many work packages, the holistic view we try to explain here, why it is indeed necessary to keep both parts in mind, not only the using of big data to find evidence, but also, and this is about the duality of evidence, of criminal evidence, also to be in the same way responsible for the avoiding of the miscarriage of justice, because this is what it comes down to. I will get back to this in context or in preparation of the checklist idea. So yeah, please have a look into the work package comments, and we can easily get back to that and discuss issues. So next slide, please. In the end, we offered some general recommendations. I can go through this very quickly. This could also be something to be reflected, to ask whether this has been sufficiently reflected in the work packages. This issue of information governance is the own part of professional role in the chain of evidence, already integrated enough within that governance concept. Transparency, of course, is a big issue. We come back to that part. Next slide, please. So the standardized report structure, they're all not new, just maybe this more holistic view. Then the checklist, which I will pick out here from the general recommendations and elaborate on this in more detail. And also, just to highlight that the importance of the worst case practice, point 4 and 5 will now play a role, because this all brought us also to a not completely new idea of producing a checklist within that governance cycle to connect all these professional groups and finally empower the courtroom participants to, as the law requires, independently and autonomously double check and assess the reliability of evidence, and not just being in the hands of IT experts and just believing things. We will see why this cannot be the way, and why this would finally jeopardize the basic structure of rule of law, which I believe nobody wants to give up. Next slide, please. I mentioned already the checklist idea, and I will just start with a brief summary at the beginning what brought us there. So we have these ethical values, and think, and I hope we could make our point so far, that we have to bring these two sides in the right balance, as using the potential mobile phone evidence, but also upholding high standards of rule of law. Next slide, please. What then is needed to be considered is that we have a normative framework which starts with these ethical guidelines or principles we just tried to explain or outlined in the report. Then we have, and work package 2 has done lots of work on that and is still in the process of dealing with that. We have criminal procedural rules which have to be applied, adjusted maybe even to digital evidence production. Then we have the standards, work package 3, on a let's say more technical level, but then still we have that operational level, and this is yet, in our view, well, I couldn't say not covered. Don't get me wrong. This is not what I want to say. But the question is whether this checklist idea, and now I come to that point, could be more helpful to find something like a concept and a practice in which the strength and the possible risk or weakness of evidence is presented in a way that from the beginning till the end meaning the courtroom, participants, finally the judges, are capable to participate in that assessment of the reliability of mobile phone or mobile device evidence. Next slide, please. This is actually what I said. Now I should have asked for the slide before, that this ultimate reliability. I prepared because I can tell you that my network, I myself was for quite a few years an analyst at an international criminal tribunal. So I worked together with IT forensic experts and analysts and all kinds of professions around that. So what I try to explain to now could still sound like too pathetic, too abstract. I will go through, that's why I prepared here 3 little excurses, perspectives, which hopefully will remind all of us that what we are after here is highly significant and important. And one book which just came into my hand 2 weeks ago is this book from it's new, from published 21, from Garrett, Autopsy of a Crime Lab, Exposing the Flaws in Forensic. It's kind of a historical perspective, and looking into forensic, and actually looking into forensic more in the perspective what went wrong and how many thousands of cases. We are not talking about just collateral damage, shit happens, sorry. This is a systematic failure of forensics. If you look into that book, and this is not to blame anybody, but it is to make all of us aware that this second side exists and that we have to do something about it. And again, why referring to that? So I would come back to what I said about the dual meaning of criminal evidence. One, to produce inculpatory evidence, but second, ensuring that exculpatory evidence, including evidence which was assumed inculpatory but is unreliable, is presented frankly to the courtroom participants. And this requires, well, or could be reflected in such a checklist. And why is it so important to look at that second part as much as at the first, to hunt the criminals down? And I quote from that book. I mean, it's a quote in the quote from a victim who spent, if I remember that correctly, 30 years for nothing in the court until DNA could exonerate him. And he said there should be some kind of regulation. There should be some way that experts have to meet a bar, a very high bar. And now this is actually what we all have to keep in mind, because you end up ruining people's lives. And this is important to keep in mind, that this has to be systematically controlled, that evidence is reliable. And IT forensics, that's I would like to work on this a little bit, and I like to refer to aviation issue, reliability issues, and I think maybe this could help. IT forensic experts should imagine themselves as airplane engineers who are not only responsible to make the airplane fly, but also make sure that it is not going down. And why is there an extensive research in learning from aviation accidents, sometimes going on for years? That is that repeating such catastrophe should be avoided by all means, because life is considered to be a high value. And now, if I compare this, if I compare this aviation standard to the situation with the processing of digital evidence, I can only conclude that the avoiding miscarriage of justice is not as important as avoiding flight accidents. That's the situation at the moment. Even though wrongful convictions destroy thousands of lives. Who now thinks that I'm dramatizing and be too pathetic? I refer to that already. Just go into criminological research about the miscarriage of justice and you will find enough proof for my statement. And what now has this to do with FORMOBILE? I think, Bernhard, I can also speak for you. We consider FORMOBILE to be a real great chance to openly look into those issues and try to find an approach to balance the investigative side as well as making sure that criminal evidence avoids, in the end, the wrongful conviction of innocent people, or at least not proven as guilty. Let me flip through this because time is somewhat running. What is needed is, and this is back to the book of Garrett, that we need a culture of openness to criticism. And Garrett states, and I saw this in the courtroom, what is most surprising is that many forensic examiners do not use methods that are based on solid scientific research. Indeed, with the exception of DNA testing, that's his conclusion, the experts who link evidence to a particular defendant at criminal trials cannot give you a straight answer to the question, how reliable is your evidence? Maybe this is an overstatement, but I myself saw analysts and cyber cops in the courtroom who could not deal with the question, what was your analytic question provided by the prosecution? So they looked at me like I'm an alien. So, and this shows that there is a quality issue which could be first. And Garrett summarizes and says, first, we need to replace definite conclusions with real error rates to clearly set out the limits of forensic methods. Second, we must require forensic experts to disclose that information in their reports and in carefully limited court testimony. This reminds to my analogy or metaphor with the flight engineers or the airplane construction and engineers, that of course pilots are very much trained on accidents to avoid crashing down, and something similar is might be needed here. So it goes on. I don't want to review this book now, but I hope I made it a little bit interesting for you, maybe to even go into that book. And there's a last issue I would, which we stressed actually in our report, but which is also a conclusion. It's one of the last, if not the last chapters in that book, and it's referring to judges as a gatekeepers. If judges, and this responsibility, of course, goes first also to the judges and the prosecutors. A footnote, this might be a trigger for work package 7 to think whether and how this can be integrated. I know the draft curriculum, and it's already heavily integrated when it comes to how to look into the limits of reliability of methods. But to empower the judges as gatekeepers is a very important issue when it comes to digital evidence. And Garrett demands that judges must rethink their role as gatekeepers, and that they need tools for conducting systematic reviews. And this leads me back to the presentation in the PowerPoint slide. Next slide, please. That these tools are missing, but possible, we know actually for sure from the Danish telecommunications scandal. That's my excursus too, to show that this is all real happening in practice and not just made up from a kind of abstract ethical perspective. And what we can see here is in the ex post review of Deloitte, there is a D missing from the Deloitte's ex post review conclusion, because they were called in. I'm sure you all know that case where in the end more than 10,000 criminal cases had to be reviewed, and 32 people already in prison had to be released, which I think everybody can call a scandal. By the way, in Germany, we have a similar issue, not of that magnitude, that there is a telephone company, and it is interesting to see how the ministries of justice react to that in different countries. You might know that justice is a country matter, I mean federal state matter in Germany. But this is still going on, this gap between the demand to assess reliability of digital evidence and the skills to do that. Next slide, please. And Deloitte came up with a checklist, actually, after they scrutinized, they evaluated the process. They were called in, I think, by either the Ministry of Justice or this was a big also parliamentarian scandal in Denmark. And after they analyzed everything, including and first and foremost, of course, the technical side, the IT forensic side, they could identify potential sources of error and uncertainty. They found obstacles and kind of weaknesses in the national police system for storage and processing of historical teledata, and the study of quality control. These were the main 3 points. And I'm not saying we can directly turn that into something useful for mobile. But this is more as an example that it is possible to identify these crucial issues, which, if they would have been aware, could have avoided this systematic use of unreliable digital evidence at court. Next slide, please. This is simply spelling out, for those who want to have a deeper look into that, the point 6. The potential sources of error and uncertainty in the use of historical teledata. I will not go through this for the sake of time. And next slide, please. Our friends from the police college in, no, sorry, this is, oh, wait, now I'm already in the next slide. In this slide, you see that Deloitte also did an 8-page briefing note for police investigators, prosecutors, defense lawyers, and judges. What they should be aware of in dealing with CDR and cell tower data. So, and something like this would be very helpful, but this has to happen on a case-related basis. And we could think about this, whether it makes sense to produce something or guidance how to produce something like that in the perspective of the FORMOBILE project. And next slide, please. Yes, this is what I started to talk about, that our friends from the Norwegian Police University College have also done a very productive review of that case, and you can read about that in that article, which is presented here in the title and also in the source. And it also refers, I didn't go into the issue of a defense, but from the discussions within the project, we know, and we criticized that in the report, that the defense is kind of neglected here. But the defense is an inevitable part of that rule of law due process system to eventually find possible flaws in the evidence. So of course, also the defense has to be empowered, enabled by training, but then also throughout the court process or the evidentiary procedural process to be able to ask the right questions. In the Danish case, they could not. But the world is changing. And next slide, please. And this is my last excursus to show that we are possibly, even though slowly and for my taste too slow, towards better times. We all are aware about EncroChat and Sky ECC and Anom, where encrypted mobile phone systems have been hacked, and the evidence now is literally pouring into the courtrooms because the wealth, quote unquote, of that information in terms of detecting criminal activities and identifying the persons behind it is so great that hundreds and hundreds of criminal cases are ongoing at the moment. And in that context, a look into the EncroChat discussion, maybe next slide, where I choose Peter Sommer, who I saw commented also on the CBA, the professor from Birmingham, who is deeply involved as an expert witness also in EncroChat. And he refers in his comments, so far as I could see in open sources, very much to the lack of applying and finally using standards which are actually established already at a basic level. And maybe you can go to the next slide. There I list something, or I just quote what he is saying. He refers to the ACPO principles and then comes down to these 4 basic principles which are not respected actually in his view. So whether he is always completely right or wrong doesn't matter at the moment. Why I put this in here is to show that there is this gap I was referring to between the standards on the one hand, and finally the capability as a judicial procedure to use the courtroom as the final test and give the judges the role as a gatekeeper and to protect for miscarriage of justice and wrongful conviction by, of course, using that evidence. So I personally don't believe that there's any bigger contradiction in terms of that it would limit the use of the evidence, but it would in the end make the evidentiary procedures much safer and more reliable as it is now. And I don't wanna play the devil's advocate, but as we saw it with DNA, that later on through DNA, many of the fingerprinting and hair comparisons, Garrett goes through this in length, has been corrected, sometimes too late. Some people have been executed in the US for that innocently. I really hope this same thing doesn't happen with the digital evidence. And again, for mobile might be a good point to think about how this can be reflected and translated into work procedures. And what we could see in the discussion process around the CWA, there are the elements already. The question is whether something could be done on top. And with this, I would give up to Denitsa, who wants to go further in that question or idea of the checklist. Sorry. Denitsa, the floor is yours.
Thank you for handing me over the floor. I think that this also is part of the conclusions of the Ethics Advisory Board in their second report. But more or less, the idea of the checklist stems out of the necessity to have a sound governance, information governance at place, which is aligned with the chain of custody, so that the evidence that is presented at court is really it's not only court proof, but it's an evidence that could really prevent the risk of miscarriage of justice. So maybe if we can go to the next slide, Julia. Yes. So the idea that was elaborated by the ethics advisors, and something that we have also commented in the scope of the our working group during the CWA meeting, was to start a working group within the project to draft a sort of guidelines in order to navigate forensic examiners in their daily work when performing analysis, but also acquisition and decryption of mobile data. The idea of this working group would be to include not only us as people with legal and ethical background, but also those of the partners who are with expertise in the technical process itself, in order to really have meaningful results, and in order for us to have really something that is useful to the forensic examiner. As we have more or less volunteered to chair this activity, we would be the ones who would structure the process and who would more or less also be responsible for its coordination. But at the end of the day, in order to have something really useful, we need to have on board also technical leads in the project. And we are also well aware in terms of the limited time that we still have in the project. We have less than a year now, but in order to have really insightful outputs, we would aim to just initiate this activity, striving to deliver some kind of guidance, but we wouldn't necessarily aim at something that is in a that is something finalized, but would like to start out this conversation and to start out this working group. Although I do believe that until the end of the project, meaning until April 2022, it is feasible to have something at hand, and we can also report it either in the CWA or in one of the deliverables that comes out from work package 2. Again, in order to have this thing going, we need to have on board also the technical leads. And as far as I'm informed, Christian Hummert has already agreed to participate in such a working group. Of course, given that our ethics advisors work very hard on the project in their spare time, we would also like to spare them and not to overwhelm them too much with their work. So I would suggest that they would only act again as advisors, as reviewers, and not as actually drafting on these guidelines themselves. I hope that you have already managed to understand better what we mean by checklist idea, and I hope that you would find it also something that is worth of your time and your efforts until the end of the project. So we'll be very grateful if you actually come on board and agree to work together to deliver such a guidelines document. So maybe if you have some immediate thoughts, or you have some immediate reactions to this idea, or maybe we're now slowly transitioning into the discussion part, or maybe you would like to pose additional questions to our advisors, in relation to what you have just heard. So I would actually encourage you to raise your hand so we can directly go into the discussion mode.
Sorry.
Yeah, well,
It's Julia
Julia?
speaking. I only wanted to say that we had one comment from Rune.
This is what I would like to comment on, if you allow.
It's in
Hello?
the chat. Okay, sorry, I didn't see it. Yeah.
Yeah, so Rune makes us aware that there are problems with the error rates and that it is not agreed on how they should be computed, and tools are often closed source and error rates are missing. Well, this, of course, is a big issue, how to approach that. And this goes even beyond our realm or sphere of applying standards and tools, also to legislation. There are different positions in my view. Like Garrett says, and I would tend to agree to that, to protect from miscarriage of justice, because I find this very important, to protect the innocent as much as to hunt down the culprits, that such evidence cannot be used. He even requires legislative activities that black box tools, tools where they run in a black box and we are not in the position to see how that process is going on. That's, by the way, one of the critical issues with EncroChat. Nobody knows, technically speaking, Sommer complains about it, how this data was retrieved and what could happen to the data on the way of processing it. In the Danish case, it happens exactly at that threshold from the telephone system to the police system, that the data were falsified. So this is a big question. But what we need to be aware is now not to say, okay, this is what it is, so we live with it, because then we accept that big risk and damage for the rule of law. We have to solve that, and legislative would be one. What they all try to strengthen is actually a central institution, which like the NIST, the NIST, and this is a discussion in work package 3, as far as I remember, maybe work package 2 as well, whether Europe needs that institution, which is safe enough to also have a look into those black boxes. What I want to say is, yes, this problem exists, but we should not step back from here, but to look for solutions, always with the end to make the trial and the digital evidence safe. This must be the ultimate goal. The plane must not go down. This is the goal.
Okay, so we have 2 more questions. The first one is by Mike. So whether our work on the path towards delivering guidelines would overlap with the CWA.
So wait, I have to see this. So that's the proposal for. If I may, Bernhard, so I don't want to occupy that discussion here, but if I may first, yes, of course, it overlaps, and quite a few elements of such a checklist is in there, but the checklist idea, as far as I myself understand it at the moment, this might change throughout the time working on it, but this is to apply it to a case at hand, make it part of the report, and having it in an understandable language for the courtroom participants. And this I haven't seen yet. So that this overlaps, that's more than natural in my view. So,
Perhaps I may add something. There are three different parts which may be relevant to this question. First, there are some technical restrictions in IT forensic software and tools, which may occur some error rates already technical driven. And second, there are procedural questions. It has to be balanced, the two different aspects. First, the look of defending the results of forensic analysis, and second, the impact which may result on these analyses. And the third thing is the difference onto the knowledge base of all participants in the courtroom, which differs very much. And because forensics, I do know very good, are speaking in another language than lawyers and other people, so it's hard to understand. And I think the good idea of such a checklist is to settle it down, to make it understandable to all participants in the courtroom, what's relevant and which could influence the results.
And maybe if there is nothing else, I also agree with the idea of the checklist. We have discussed this internally with the ethics advisory, because the idea is to have some kind of, not like a standard, but some useful guidance to the forensic examiner in terms of what kind of steps he needs to go through and how he should present his or her results to the court in easily intelligible and understandable way, so each party of the proceedings could understand what actually happened and not arrive at a opaque black box where nobody understands what actually went through, which is now being observed in the EncroChat. So there is another question in the chat by Kurt. He asks that he points out that the main focus has been on the analysis part, but which kind of ethics considerations play a role in the process of recognition and acquisition of digital evidence?
Well, if I may step in here again. Yeah, it's true. We actually could and did not aim to cover all the phases of processing the evidence for different reasons. One being not being expert enough to do that in different phases. So that's why the cooperation is needed. But just what comes to my mind looking at your question, what is important in terms of ethical, and I would add even legal rules at the beginning, is while go through these big blocks of ethical. Number one would, for me, always be the governance. Of course, you need a court decision usually in Europe. The other is just to kind of explore a little bit, right? There's no systematic behind what I'm saying now. The other is, what we have is trans-border access to digital evidence could play a role. Data protection. Are there privileged groups? This is when you acquire data, can you easily grab into, that's one of the complaints in German courtrooms, by the way, to say, according to German law, you could not have done what EncroChat, I mean, the French police was doing. So can we use now? Is it admissible, even though it was acquired, the data in a fashion which wasn't allowed in Germany? The court rulings so far, and also as far as I see, the European Court of Human Rights rules that it is admissible. There are a few decisions that not. So the next big block would be everything which goes to the professionalism. So again, what we tried is actually we would have to go back to answer that question in more detail, or maybe Bernhard can comment on that from his more in-depth view. But to go through that pattern which we try to offer, and also what this workflow drafted by Work Package 1, and then we probably would find a list of ethical legal principles which would have to be recognized and respected throughout the process of acquiring and processing at that entrance stage digital evidence. I wouldn't see any difficulty. And now, just referring to the checklist idea, now to know that that there are crucial elements or crucial issues, just to make a note, which actually should be in a normal report. But reports I know, I'm not saying I know all reports or representative sample, but the reports I know, and I know quite a bit in the German context and partly in other countries, this is the quality and the standard of those reports is very, very different, and normally it would be included. Yeah, this would be my, sorry that I can't be more detailed, but I would go into that direction. But personally, I would not be able, without the help of IT forensic experts, to really go into details. And I think the slide from Work Package 1 actually contains quite a few references to steps to be done in that procedure on the IT forensic side, which could be considered in light of ethical and legal principles. Thanks.
Thank you. And I believe this is why when we speak of the checklist idea, we heavily underline the importance of having the different technical leads on board, because we are to a degree limited by our own experience and knowledge. And this is why it's important also to have people involved in the different stages, so we can work together in really to single out the legal and ethical considerations that need to be there for the forensic examiners. And actually, Stephen Collins from the Home Office actually just shared that in the UK they have just received guidance by their College of Policing as to how to obtain data from digital devices, and he has actually shared the link to the chat.
That's great.
Mm-hmm. Yeah, and also Mike has shared that a very recently published white paper on 6 steps to guide the mobile forensic examiners. I think that was a joint effort by different software vendors, if I remember correctly. Mike, if I'm wrong, just flag it out. But yeah, these are all useful resources, but we believe that as a project who is so much focused on digital or mobile forensics, it's actually shame if we do not put our efforts towards this direction. Stephen actually has another question, whether this guidance through checklist could become part of the CWA. Stephen, it can become, but I myself am not an expert in terms of how standardization process is structured. So maybe if Olga can provide her perspective and share whether this is doable or not in this time frame, would be very grateful. And in the meantime, there is another question by Rune, which refers to the error rates. So he asked, how can you compute error rates for recall or precision correctly if we at the same time utilize the minimization principle?
Well, Bernhard, you have an answer?
The minimization principle refers to the quality and quantity of data, and not of the quality and quantity of IT forensic tools and procedures. There's a difference. So it's on my point of view, there is no contradiction to that. It's a question about how valid are the results. Under which conditions do you set your analysis, and what are the results under which preconditions and so on. And that's of course I'm strictly believing to this, not a question about the data in the terms of the minimization principle.
Oh, just briefly, I mean, number one, yes, this is a crucial issue. There can be limits, but my next question, more in an analytical perspective, would a little bit follow in what Bernhard just said. That if you can define that reliability risk, number A, you would have to write it down. And number B, the question would be, is there a way to mitigate that triangulation whatsoever? If there is no way and you stay with your assessment, there is a risk, then the court should know and has to decide, can they base some conclusions on that alone? Do they need accompanying evidence and so forth? This would be the way to go. But first we have to know about that. That's actually, it's not always to find an ideal solution to that. The first thing is to know. The second is, well, if Bernhard is right, then he doesn't even see that hard link between that, but I could even accept that and then say, okay, but we know now that there is a risk. So let's go over that. Let's discuss that. Let's test that. Even ask for some expert witness in the courtroom again. But this would be the right way, and not to say, well, there is a risk, we cannot help it at the moment, so we live with it and present in our overall attitude of feeling having done our best, the evidence in a reliable way. You know, that's another big thing about cognitive bias, but that's not for now. But yeah, being aware of the risk is the first step, and then looking for mitigation. And if this is not possible, just being transparent about it, then we can leave it to the judge. And this even judge can, I mean, a lawyer can understand without knowing the details of what's behind what you are describing from an IT forensic perspective.
Thank you, Bernhard. And this is also in my mind an additional argumentation as to why we should go for working together towards preliminary work on the checklist, because the more transparent we are, the better we contribute to the rule of law, actually. And there would be at the same time increased trust in the results that are yielded by tools used in forensics. Are there any additional questions or any additional remarks any of you would like to make?
Can I give one more comment? I very much, Mike and Steve, I'm very much in favor actually of what's out there already. And I know that I never have a complete overview, even though I try hard. So if we could pull all this material together, go through an analysis and look what is valid for us, and then apply it, I would follow Denitsa in that. It still can make sense to look into the CWA, the specific standards, and either emphasize or, I don't know, even modify certain recommendations or guidelines for mobile perspective. Then the work is even more effective and maybe shorter than we thought in the first place. So if there's anything out, and thank you very much for the links and the comments in that regard. Of course, this has to be taken into our mind. Okay,
Yes,
I'm done.
of course, I have just one additional remark. Because this deliverable has been shared with the consortium, but maybe not everyone got familiar with it. Actually, the deliverable has specific recommendations for each work package, and I would encourage work package leads to check the contents of the ethics advisory board report. It's very extensive, very comprehensive, and it's something similar that usually doesn't come from ethics advisors. I mean, that's really profound. And I would, yes, urge you all to, as a work package leads, to go there and to see what kind of specific recommendations were formulated for your specific work package, so you can take them on board.
Is there still time for a question?
Yes, we still have 10 minutes more.
Okay, because I would like to have a question. When I see now this material here from what just came, the link authorized professional practice extraction of material from digital devices, May 2021, and then look into the discussion, in particular in the UK, around the EncroChat evidence. So if this is all there, why? I mean, what explains the gap then here? If actually the professional experts are aware of that, even feel in the position to write guidelines how to do it, and then if you look into the courtroom, it's not arriving there, or at least not to the extent. I mean, Sommer is not nobody. If he complains in that way, it really means something. So is there any short answer to that?
Steve here. Sadly, I don't think there is a short answer to it. My knowledge of the EncroChat prosecutions, to be brutally honest, is a little limited. However, my experience of those types of investigations is that, sadly, the approach that's taken on many occasions is we'll proceed as we have always done and let the court decide. So the unfortunate thing is that I suspect is what will happen with those prosecutions, and we will end up with a number of stated cases, and they will influence any future prosecutions. But of course, that doesn't deal with the ongoing prosecutions at that point in time. And as is always the case, two trial judges may not necessarily agree in their opinions of the evidence that's been presented to them. And because of the nature of some of this evidence, i.e. it will have been obtained in a covert way, it really makes it a difficult area to apply certain aspects, because of course, certainly in the UK, as you may be aware, they can apply for hearings in camera and not allow that evidence to be in the public domain. And as a consequence, it makes things really challenging to come up with an agreed process and application of the law and the findings from that moving forwards. The APP that's come out, if I just say that has dropped on UK policing, there's been several drafts of that in existence that I became aware of a few months ago now, and it's pretty much similar to the draft that I saw just after Christmas, and this will, without a doubt, have a serious effect on what's going to happen in UK policing with regard to the extraction of material from digital devices. And it's even worse than just mobile devices, because when you read the APP, it actually doesn't just restrict itself to mobiles. It applies to computers, to CCTV coverage. There's a whole raft of digital evidence that this APP is going to apply to. And the final thing to say in respect of that is there is a new piece of legislation which is about to land in the UK, which, whilst doesn't deal with all aspects that are covered off in the APP, because the major factor with the APP is that it deals with witnesses and with victims, but most importantly with suspects as well. So that's the real game changer with the APP, that it covers all three categories of part of an investigation. The new legislation is actually to do with witnesses and victims, so it's not quite as bad, but as I said, the APP is going to create some major headaches going forwards.
Thanks a lot.
Are there any additional reactions, commentaries, questions? I don't see any raised hands. So maybe I would pass to Anne to close down the workshop.
Thank you very much, everybody, and thank you for moderating the discussion, Denitsa. I think it was very fruitful. Julia will share, or we will share, the recordings for the session, from the session. So if you know somebody from your organization who has an interest in this topic and this discussion, or can be of help also with the recommendations from the report and how to follow these recommendations in your work packages and tasks, please share them. And so that's from my side. I wish you all a nice weekend, and thank you very much for this workshop, Uwe and Bernhard and Denitsa.
Okay, thank you. Bye-bye.
Thank you very much.
Thank you very much.
For your hard work. Thank you.
Thank you very much. Bye-bye.
Thank you very much. Bye.